10 seconds, 5 seconds, start. According to the Learned Council, even fiscal year is a defined term for Schedule 1, Clause 8 and commences from the opening date. Also, the expression term is defined in Schedule 1, Clause 17 as set out in Article 24. It is settled law that the agreement has to be read harmoniously in keeping with the principles of business efficiency as applicable in commercial contracts and by looking at other clauses in the agreement to give effect and meaning to the intent of the parties. The Learned Council stated that reading of Article 9, 1 and 2 read with Article 12 makes it very clear that the management fee and the incentive fee is also payable from the opening date only. Article 9 absolutely clear and only covers certain pre-operational activities prior to the opening of the hotel by the operator for which the respondent had to bear the said pre-operational expenses. Article 2, Sub-Article 2 detailing the various activities to be done by the operator, that is the petitioner, herein relied upon by the respondent on a plain reading clearly shows that except for the pre-operating expenses clause 2.1 referred above, all other duties and responsibilities relate only to the operation and maintenance of the hotel. For the period May 15, 2015 till July 21, 2017, the hotel was under construction and non-operational, and hence the term commended only from the opening date as defined under the agreement. Thus, till July 2022, the agreement cannot be terminated for any reason whatsoever. In support of his submission on interpretation of a contract, the Learned Council has relied upon the various judgments. According to the Learned Council, as the respondent is disentitled from terminating the contract during the lock-in period under any circumstances, either with clause or without clause, the agreement is not hit by Section 14 or 41 of the Specific Relief Act 1963. Rather, the mandatory lock-in period is an expense negative covenant within the meaning. Notwithstanding anything contained in subsection 1, the last sale or purchase of any goods preceding the sale or purchase occasioning the export of those goods out of the territory of India shall also be deemed to be in the course of such export if such last sale or purchase took place after and was for the purpose of complying with the agreement or order for or in relation to such export. The respondents have placed reliance on the decisions in Bumrah Shell Oil Storage and Distributing Corporation of India versus Commercial Tax Officers and others, Coffee Board and Madras Marine to contend that the issue is answered against the appellants. The respondents have distinguished the decision relied upon by the appellants in Indian Tourist Development Corporation. It was urged that the doctrine of unbroken package evolved by American courts has no application in India as expounded in William Fernandez. It was thus urged that the taxable event had occurred on the appropriation of goods at a bounded warehouse itself, which was within the territory of the state of West Bengal.